Next bill is Senate Bill 1, Senator McPherson and others, a joint resolution amending Article 1 of the Constitution relative to expropriation of property, prohibit the expropriation of property for use by or transfer to any private person, entity under certain circumstances. Members, I remind you that 3 pages of committee amendments were adopted by the House on May the 4th. They are available attached to the yellow copy of the bill in your packet. And did you guys ever pass out the unofficial? Yes, sir. And also at the request of Representative Bruno, an unofficial re-engrossment V3 has been produced and distributed to you to show you how the bill would look with the committee amendments adopted.
Mr. Speaker, in the chair, Representative Bruno.
All right. Mr. Speaker, members of the House, Senate Bill number 1 is a response to the decision of the United States Supreme Court in the case of Kelo versus City of New London. Its purpose is to preserve the right of private property against expropriation for economic development by transfer to a third party. That's what we're talking about. Don't listen to the obfuscation of the issue that you have heard today. When we talk about an industrial park, we're talking about a public entity that's renting space. Okay? Different situation. Often we talk about these great substantive issues and we don't really go into what brought them about or what the background is. So if you would bear with me, I want to give you some of the background, and I want to elaborate both on what Representative Townsend said in explaining why he was voting as he did, and also with respect to what Representative Strain had to say. Both the federal Constitution and our state Constitution permit the seizure of property without the consent of an owner if there is a public purpose or use and just compensation is paid. Unfortunately, prior to this time, neither the federal Constitution nor the state Constitution defined what the public purpose or use was. Worse than that, Kelo broadens those terms. And we have some state jurisprudence that also broadens those terms. What you had is you had an old city in Connecticut, New London. The city decided that they were going to have a comprehensive waterfront development after a well-known drug company announced it was going to build a facility in the area. So the city council prepared it, and it encompassed 90 acres, including 115 privately owned properties and 32 acres utilized by the government. It included a conference center, hotels, restaurants, shopping malls, marina, a river walk, a museum, an office and retail space, and parking. Most of the people involved said, okay, we'll sell you the property. Now, let me tell you what, if anyone in this room has ever undergone the expropriation process, it's a grinding process. It is Big Brother sitting on top of you. We're going to take you to court. We're going to take you all the way through court, and we're going to take everything you have, and whatever little we give you, you're going to end up paying in attorney's fees for trying to fight us. Now, that's the stick that government carries. And I'm not going to elaborate on where they want to put that stick. I think we all understand that. But 15 people said, no, we don't want our property expropriated. Now, were these houses blighted? No. Were they abandoned? No. Were they livable? Yes. In fact, one of the people in there, and somebody's going to say, well, Miss Kelo didn't acquire a property until afterwards. She just happened to be the lead plaintiff. One of the other people had had that home in their family for 100 years. 100 years. You think there's not some sentiment with respect to that? Court says. There's no evidence of an illegitimate purpose in this, and that the taking was in furtherance of a carefully developed plan. Okay? Let's take little 30 by 90 foot lots in part of New Orleans, and let's parcel them together so we have nice big half-acre places or 2 or 3 acre places where you can put condo world on them. More taxes. That's what all this is about.
Representative Snyder moves to give Mr. Bruno 5 additional minutes. Any objection? Any objection?
The court said that there's a broad difference of public purpose, a broad definition of public purpose, and a long-standing deference to legislative judgments. So, in essence, what they did is that they said that it's a matter for the states to decide. Are the states free to restrict the taking power further if they see fit? And the answer that the Supreme Court said is that nothing in their opinion precludes a state from placing further restrictions on the exercise of the taking power. In her dissent, and Mr. Strain, Dr. Strain spoke of that, quoting Justice O'Connor. And this was a 5-4 decision. She said, the specter of condemnation hangs over all property. Nothing is to prevent the state from replacing Motel 6 with a Ritz-Carlton, a home with a shopping mall, or a farm with a factory. And that's really what we come down to. You know, and there's an article in the Bar Journal, and I know some of y'all don't particularly like lawyers, but it's a very scholarly article. And one of the things in there, after listening to what the Supreme Court said about the state can do this, state can do that, here's the Bar Journal, February, March 2006. Louisiana has passed no laws specifically designed to curb the impact of kilo. Conclusions. It is likely that the number of expropriation proceedings will increase in the next several years. In view of kilo and its broad definition of public purpose, it may be difficult to challenge the public persons for these takings. And then listen to this. However, these landowners will still be entitled to just compensation in their day in court, and they will need assistance in wading through the expropriation laws to ensure appropriate compensation is paid. Another field day for my profession. Now, Senate Bill 1 is a response to this. Are we the only states that have responded? No. You have other Gulf states that have already responded to this, both Texas and Alabama. Senate Bill 1 is our response to that. It provides that except for specifically authorized things, such as ports or industrial development, as authorized by the present Constitution and subject to the limitations of that Constitution, property cannot be used by or transferred to another private entity. And that's the key to all of this, to prevent the flipping of property. Now, if you look at the bill, particularly the unofficial re-engrossment, it defines what public purpose is. And it says that the industrial district, the port, you can't take any more of that than is set forth in here. And it says a general public right to definite use of the property, continuous public ownership of the property dedicated to one or more of the following objectives: public buildings, roads, bridges, waterways, drainage, flood control, levees, parks, convention centers, museums, historical buildings, public utilities, and the removal of a threat to public health or safety caused by the existing use or disuse of the property. And then it says this, and that's the important thing: neither economic development, enhancement of tax revenue, or any incidental benefit to the public shall be considered in determining whether the taking or damaging of property is for a public purpose. That's the key to it. And that is basically what the bill does. We have some amendments to the bill. Mr. Montgomery has an amendment that I view as almost technical in nature, dealing with the ports, that I've authored and that he will handle. Mr. Cravens has an amendment that will clarify, Mr. Ansari, that with respect to industrial development, you cannot take a home even for those limited public purposes. You will have to try to buy the home. Mr. Farah has a bill that's going to take out, or rather an amendment that's going to take out some of the definitions with respect to compensation, because where you had the return after the 15 years, because his bill has passed the House and it looks like it's going to pass the Senate, so we don't need two bills on the same subject. I do have some other amendments that I will be more than happy to go into. We need to amend the proposition.
You begin to wrap it up, Mr. Bruno?
Yes, sir.
All right.
About 30 seconds. We need
All right.
to amend the proposition, and we need to clarify the provisions with respect to damages. And that's it, Mr. Speaker. I would hope that you would vote for this. You know, it's just two different approaches. This bill is basically a prohibition. Glenn's bill was basically an authorization. Are there exceptions to both? Yes. There were protections in Glenn's bill, and yes, there are exceptions in this bill. But that's the basic difference between the two bills. I'll be glad to answer any questions.
All right, Representative Snyder for a question.
Thank you, Mr. Speaker, and thank you for putting me at the top of the list on people blaming me for letting Mr. Bruno speak longer.
Oh,
I took my pill this morning.
complimenting you.
Mr. Bruno said he took his medication today, so
Seems to
we
be
ought to be
working
all
real
okay.
well so
We're
far.
all safe. Mr. Bruno, I think there was some
Yes, Mr. Snyder.
testimony earlier about industrial taking of property and what SB 1 was going to handle, but it was my conclusion from the current Constitution that that is enabled now. Is that not correct?
That is absolutely correct. The bill simply takes cognizance of that.
Okay, and
So that makes no change in the present law.
that's what I thought, Mr. Bruno. Thank you.
Representative Ansari for a question.
A few questions, Mr. Bruno. And I think we discussed it, and I think you addressed it in your opening, that Senate Bill 1 does treat industrial uses different than commercial uses. Is
Yes.
that correct?
Yes, because
Okay.
that's in the present Constitution.
Okay, so Senate Bill 1 will allow the taking of the family home, family farm, private property to build a manufacturing plant or a refinery. Is that correct?
Potentially, yes.
Okay.
But not to flip it, which is what your bill would have done.
Hold on a second. I'm looking at the re-engrossed version, Pepe. When they talk about, on page 4, where it talks about the industrial use, and this is, I guess, is the existing law. It authorizes the taking of, to acquire industrial plant sites and other property necessary for the purposes thereof, page 4, line 10.
That's the present
To
law.
acquire through purchase, donation, exchange, and expropriation, and improve industrial plant buildings and industrial plant equipment. And in paragraph C, it authorizes them to sell, lease purchase, or demolish all or any part of the foregoing property. So this is the authorization in current law to allow
This is
the flipping.
This is the current Constitution
Right.
with respect to industrial development.
Right, but your
Okay.
analysis that, your representation to the body that it wouldn't allow the flipping of the property, the transfer of the property if it was taken for industrial use is
It's
not
allowed
correct.
now, Glenn. This bill is
Right.
not going to allow it. It's allowed now.
Right,
Well,
so-
Wait. May I answer your question, please? What we're trying to do with this bill is to prevent any further erosion of rights. Now,
I know.
if you want to come take out all that stuff about industrial development and repeal the industrial development, be my guest.
No, I'm not saying that, but I'm saying,
Because Cravens has...
I
an
understood.
Actually, what you should do is vote for Cravens' amendment that we both can offer shortly.
Well, I'll talk to you about amendments in a minute.
Oh,
But I just
okay.
want to make this point. I
Point is, we
understood.
can make the bill stronger. with
I
President's
understand,
amendment.
I understand your presentation was that my bill would allow the flipping of property for industrial use. This bill wouldn't, but in
And
fact it
commercial
would.
use. And
In fact, it
residential
would.
use.
In fact, it would,
No.
because that's existing
No,
law.
Glenn. No, Glenn. That's a great argument to use. It's a good lawyer argument, but you and I both know that that's not correct because the present Constitution says that right now.
Okay, let's talk about
Right
amendment.
now.
Let's talk about,
That's why it's not underlined, Glenn.
Yeah, I understand that, Pepe.
Okay.
But you can take, under Senate Bill 1, you'll be able to take Mr. Kenny's farm to build for an industrial use purpose and sell it to Toyota. You can
do
flip
that
it.
now.
Right. You agree with me?
You can do that now.
Okay.
Not under the bill. The bill is repeating what the present
Okay.
law is.
Let me ask you a little bit about the amendments. You talked about some of the amendments you have coming.
Yeah.
I had an amendment that I put at the desk last week. I had two amendments.
Mr.
actually.
DeWitt, why do you rise? Excuse me, gentlemen. Mr. DeWitt, why do you rise?
Look, can we just maybe debate amendments whenever they're up?
Yes, let's stay on the bill. Good point. Let's stay on the bill, and we'll get to the amendments next. Go ahead.
It was a very important question, Mr. Speaker. If you allow me a little latitude here.
Well, let's wait till we get to the amendments, and then I'll recognize you for a question at that point in time.
Okay. Pepe, you and I have
That's
talked.
me.
I know you and I have talked about this a number of times, and
Many times.
and my debate on the bill, I'll look at Senate Bill 1 as a knee-jerk reaction to a problem that was brought to light by the Kelo case that really doesn't exist in Louisiana. I mean, that's what I believe.
From a legal standpoint, I disagree with you because of certain court decisions that we've had. I think with Kelo, the door is now wide open.
Okay. So you don't agree with me that it's a knee-jerk reaction?
No, I
Okay.
think the other reaction was I don't want to say what I thought the other reaction was. It's got something to do with jerk.
Okay, and you talked about the cases in Louisiana. Mr. Strain talked about cases in every other state but Louisiana. And, but the cases in Louisiana, the only ones I can find was 3 cases. One involved the Exhibition Hall Authority,
Right.
which filed suit against the owner of commercial property in 1993. Are you familiar with that case?
Somewhat.
Okay. Well, do you agree with me that the property that was acquired was not residential property, it was commercial property?
I think it was.
Okay. And the second case, City of Shreveport sued to acquire commercial property for a convention center and a convention center complex, and that was the Second Circuit case in 2001.
That's right.
And once again, it wasn't a family home, that was commercial property. You agree with that?
I think I agree with that.
Okay. And the third instance was Town of Vidalia sued an unopened succession to build a hotel commercial retail center, Third Circuit case. And I understand discussions with Mr. Hammett that the property they sued over was not residential property, was property that was used for industrial use.
Well, I don't know anything about that.
Okay, if I would tell you that was the case, you wouldn't have any information to disagree with that.
Or agree with it.
Okay, so my point is the 3 cases that we're talking about that involved the expropriation authority in Louisiana all had to deal with commercial property
Yes.
and didn't
But
have.
wait, Glenn. You asked me a question, my turn. I was quiet while you did. Now you got to be quiet while I do. The difference is Kalo versus City of New London, which opens up the whole panoply of government takings. Absent Kalo, we wouldn't be here today discussing either your bill or my bill, and we both, or Senator McPherson's bill, which I have the privilege of co-authoring with him along with many other members of the House.
So it was the issue involving Suzette Kelo and the City of New London case, right?
Sure it does.
And Suzette Kelo has
That's why it's happening all over the country.
Right.
That's why Texas did it. That's why Alabama did it.
Okay. Mississippi
Why
hasn't done
Ohio did it.
Mississippi hasn't done it yet, is that correct?
Yet.
They haven't done it, have they?
Yet.
Okay.
I mean, I only have cases as of December '05. And, you know,
All right, the gentleman's out of time. Give him additional 2 minutes and out of objection. Two minutes.
Would you agree with me that since the Supreme Court decision, the name of Suzette Kelo has become very well known across the country.
I would think so, yes.
Okay. Can you tell me, Mr. Bruno, the names of the Louisiana citizens whose homes were expropriated under existing Louisiana law for economic development purpose? Can you name those citizens?
No, Mr. Ansari, I can't. I wasn't the lawyer in one of those cases seizing the property from those persons. If I were the lawyer who was the one who had the saliva dripping from my mouth as I took somebody's private property, maybe I would know the name of those poor souls who were evicted from their homesteads and destroyed by the giant maw of government.
What bill did you take?
But I will tell you this. I know a lady by the name of Ramona Bodie. She lived where the I-10 was.
Martini, why do you rise?
What bill was it that he said he took this
He
morning?
needs another one. Go ahead, Mr. Bruno.
Oh, no, this is all a controlled debate, Mr. Martini. You're a good lawyer, just like Mr. Ansari. You know, you have to emphasize some points, and you have to put a little humor in some points. But I do know about one case. It's the first case I ever handled. It was a lady by the name of Ramona Bodie who lived on New Orleans Street out in Gentilly. And her property got taken for building the I-610. And there was a lawyer with the Highway Department by the name of Bill Irwin. Good lawyer. Real good lawyer. They came in, and like they always do when they expropriate things in the Highway Department, they threw the money on the table and said, here, we're taking your property under the quick-taking statute. That's another little seamy underside of what all expropriation is about, where they just come in and they grab your property, and they throw the money on the table. So she went to a gentleman that I was doing some work for, who's now a federal judge, and he said, well, you know, you handle this case, I'm going to work with you on it. And we did, okay? You know what they ended up telling me? We won in the trial court. Not on the taking, because a quick taking says you can take it, but on the dollars. And he said, let me tell you something, son, because I was a kid, wet behind the ears. He said, I'm going to grind your client into the dust. He says, we're going to the Court of Appeal, and we're going to the Supreme Court. And I told that poor lady that, and she said, you know, I don't care if I don't make a penny out of it. And I said, well, you know, you game, I'm game. And that's how government works. That's what he said, we'll grind you into the dust. Won the case. And the lady finally got her money. And I didn't have it on a contingency. We had it on a set fee.
The gentleman's out of time. Mr. Clerk, let's take up some amendments, see if we can kind of move some off of dead center here. You have amendments, Mr. Clerk?
The first one is by Representative Bruno. It is 393.
Representative Bruno, on your amendment, 393.
Mr. Speaker, members of the House, this deals with the compensation language, and it really is a clarifying language to that, because it's just not phrased right. And it's, you know, right now it says include, and we say include but not be limited to, and it provides that the word otherwise means other damages. So I view that amendment as technical in nature. I'll be glad to answer any questions.
Representative Ansari, do you have a question on this amendment?
Okay.
You're recognized.
I have a question on this amendment and other amendments. Mr. Bruno, last week I put an amendment at the desk, two of them as a matter of fact. One that changed some ballot language, and a second one that dealt with excluding industrial and economic development districts. And when I put it at the desk last week, I was the first up. And then when you filed the amendment that you just explained, that amendment was filed yesterday, and since it's the author amendment, you're able to take it up before my two amendments. Is that right? You're the parliamentarian. That's generally correct, right?
Yeah, that's right.
Okay. And then today you filed 4 other amendments,
Yeah.
which move my two amendments from positions of first and second to now I'm 5th and 6th
Okay,
because of the 4 other amendments you filed today.
that's right.
My question to you, sir, is would you oppose any motion to end consideration of amendments until I can take my amendments up later during the debate?
I don't have control over that, Mr. Ansari.
I'm just asking you if you would oppose any motion that might, and I'm not saying a motion will be made,
Well, I
But
don't
if a
know
motion
whether
is made to end consideration of amendments because of the 4 amendments you filed today places me way down the list, would you oppose
Well,
any
Glenn,
motion to end consideration of amendments?
I'm not sure what your amendments do, so I can't make that decision until that point. I'm not going to make any motion like that.
I know, but would you vote against the
I
motion?
don't know. It depends on what the amendments say.
Well, one
That-
amendment, you've read those amendments, one had to do with ballot language, and one simply...
I don't have a problem
and one,
with the ballot.
And one simply
Wait,
excludes
wait.
the economic development industrial districts. You know what they do.
I don't have a problem with the ballot language amendment. That's obviously something that got left out in the committee with the committee amendments. In fact, I had that amendment too. So great minds obviously run in the same channels.
So you're not able to make that commitment to me.
Not at this point in time, but I'm not saying that I won't.
Mr. Ansardi, do you wish the floor on this amendment? All right. Any objection to the adoption of the amendment? Any objection? Without objection, amendment stands adopted. We have other amendments, Mr. Clerk?
410, Mr. Speaker, is by Representative Bruno.
Representative Bruno,
Glenn,
410.
I think this is the amendment that you talked about. This is the proposition language to put the exceptions in the proposition with respect to the operation of public ports and airports and for the expropriation of property for industrial development purposes. And that's, I believe, the same as an amendment that you just said that you had with the proposition language. I think it is. And that's what it does. It clarifies the proposition. And I view that as technical in nature.
Isn't it the same as yours, Lynn?
Right, on the amendment, Representative Ansardi, you have a question on this amendment?
Mr. Speaker, this is a technical amendment to the proposition.
Any question, Mr. Ansardi, on this amendment? Okay. Do you wish the floor on this amendment? All right. Mr. Montgomery, do you wish the floor on this amendment? All right. Any objection to the adoption of this amendment? Any objection? Out objection stands adopted. Next amendment.
Is 411 by Representative Bruno.
Mr. Bruno, on 411.
All right. I've offered this amendment with respect to the public ports and airports, and it clarifies that they do have that type of authority to facilitate the transport of goods or persons in domestic or international commerce. So if you build public, not flipping it to private entities.
Right. Mr. Ansardi, you have a question on this amendment? Mr. Robbie Carter, do you have a question on this amendment?
Representative Bruno.
Yes, sir.
I don't have any ports up my way, but I do worry about airports. Now, you're telling me with this amendment, it would only be for a public airport?
Yes, sir.
And there's no way that the public could expropriate the land and flip it to a private entity to do that?
Not under Senate Bill 32.
All right.
I mean, under Senate, I'm sorry, Glenn. Not under Senate Bill 1.
Mr. Montgomery, do you wish the floor on this amendment? All right. Any objection to the adoption of the amendment? Any objection? Out objection, amendment stands adopted. Next amendment, Mr. Clerk.
Is by Representative Bruno, 413.
Representative Bruno.
All right. Glenn, you ought to be for this one because this limits the industrial development, and it says that the homestead, as defined by the Constitution, shall not be subject to expropriation for the industrial development. And that's at the suggestion of Representative Cravens, who I think...
Representative Robbie Carter, do you have a question on the amendment?
Pepe, did this now give me the house and 160 acres?
Yes, sir.
All right, so I'm not limited to the 5 acres now.
No, sir.
Representative Cravens, you wish the floor on the amendment? Okay, you're recognized.
Thank you, Mr. Speaker. Members, when this bill came to committee in the Civil Law Committee, I looked Senator McPherson in the eyes and said, Senator, I don't want to kill your bill because I think it's an important instrument that needs to be discussed by the House on the floor, but I have serious concerns about it. It was inconsistent. The bill the Constitution is inconsistent. As it stands now, and as Representative Ansardi has said, and also Representative Carter and Walker and Townsend, they can take your family home, they being the government, They can take the best parts of your family plot if it's for an industrial purpose. And I told Senator McPherson at that point, Senator, we're going to have to work on that. And he agreed to do that, and I must say he's been very honorable in doing that, because what this amendment does, it says, at least where you live, as defined by the Constitution, your homestead, and at least 160 acres if you own that much around that homestead, will be protected even from the industrial taking. Because my citizens back home are telling me what I think they're telling you. We don't ever want our private property, where I live, my home, my farm, to ever be taken by government to be given to another entity, whether it be a Nissan dealership or a Nissan plant. We don't ever want them to take that, the government to take that from us. If we choose to sell it, that's one thing. And that's what this amendment does, and I think this amendment makes Senate Bill 1 as consistent as it can be made, so that you can go home and really tell your citizens, really tell your constituents, we passed meaningful legislation that will prevent government from taking the family farm, from taking the family, the home.
Question, Representative Ansardi on the amendment.
Mr. Cravens.
Yes, sir.
So this would allow the family farm in 160 acres to be protected.
Correct.
But don't we have farms a lot bigger than 160 acres?
We do.
So it would allow the rest of the farmland to be taken for uses. It would, right?
It would.
Okay.
All right, Representative Hunter for a question on the amendment.
Don,
Yes, sir.
let me give you a factual situation that you know. Suppose you have the homestead, and you have an infirm, an impaired majority person living in that homestead. The parents are deceased, both, but the infirm child is still there in that homestead, and so the homestead has never been forfeited, and that child, along with sisters and brothers, own the property in division. Can you still claim the homestead and still be protected under your amendment?
You're still protected, because if you read Article 7, Section 20, Representative Hunter, it says in the paragraph, owned and occupied by any person or persons owning the property in division. So that's also in division.
Gotcha. That's what I'm looking for.
And I wanted to say to Representative Ansardi, you asked the question, there are farms bigger than 160 acres, and you're right, but what I think makes this amendment, I mean, your bill said 5 acres. You know, this says 160. I mean, I don't think we can ever pass a piece of legislation that will account for every situation, but I think the 160 is expansive enough to cover most homesteads.
All right, Representative Townsend for a question on the amendment. Gentleman waves. Representative Mike Powell for a question on the amendment.
Just one quick point. It's true that this actually now is going to provide a protection for homesteads that's not in the current Constitution, isn't that right?
That's correct. In 1974, the voters voted to allow an industrial exception in the eminent domain. I don't think the voters want that anymore. My voters are saying, I don't ever want you to take my homestead without me negotiating that with an entity.
And my voters feel the same way. Good amendment. Thank you.
Thank you.
Representative Ansardi, do you wish the floor on the amendment? Gentleman waves. Mr. Bruno, you have a right to close on the amendment.
Mr. Speaker, members, I think that Representative Cravens has explained the amendment extremely well. It certainly answers the questions that Glenn had about what are we going to do with respect to the homeowner with respect to industrial development. It says very simply, go to the homeowner and try to buy the property. That's the American way. So I would urge you to vote for Representative Craven's amendment.
Any objection to the adoption of the amendment? Any objection? Out objection, stands adopted. Next amendment.
Is 414 by Representative Bruno.
Mr. Bruno,
Mr. Speaker, to members of the House, what 414 will do is basically delete the buyback provisions that were put in committee because Representative Farrah's constitutional amendment is over in the Senate now. It is in the Senate now, and there appears to be little or no objection to that amendment. So We don't want to have conflicting provisions with respect to that in these two bills, so it will take out those provisions.
Right, Representative Farrer, do you wish the floor on the amendment?
Yes, sir. Thank
All
you,
right,
Mr.
sir.
Speaker and members. This is something we've been working on. We're trying to work out some language. We don't want to have any confusion between the two bills. HB 707 is already on the Senate side. There's been very little, if any, opposition to it, so we're going to try to take it out of Senate Bill 1 so that there won't be that confusion.
Representative Strain, you wish the floor on the amendment? No. Okay.
I'll make the motion we end consideration of amendments.
All right, we have 4 amendments pending. Mr. Ansardi, why do you write? Yes, it is. I apologize. It is not debatable. In consideration of amendments, not debatable. Mr. Ansardi, why do you rise? Request a lockout. Would 20 members join him in that request? A lockout has been requested. 20 members join him in that request. Are you through voting? Are you through voting? A lockout is obvious. We'll have a quorum call. Vote only your machine. Vote only your machine. Quorum call. Mr. Abear is here. Mr. Guyman, Mr. Cleckley, Mr. Mickey Gilry is here. Mr. John Smith's here. Ms. Dorsey is here. Are you through voting? Are you through voting? Close the machine, Mr. Clerk. "92 members present and a quorum." Representative Ansardi, you're recognized for a motion.
I'd like to make a substitute motion to call the question on this amendment.
Any objection to the substitute motion to call a question on this amendment? Any objection? Without objection? Mr. Strain, do you object? All right. There is objection to the motion to call a question on this amendment. Many of you in favor of calling a question on this amendment will vote yes. Those opposed, no. The clerk will open the machine. You'll open it up, Mr. Clerk. Vote your machines, please. We are vote only your machine. We are still under a lockout. Ms. Dorsey, yes. Are you through voting? Mr. John Smith, yes. Are you through voting? Clerk will close the machine. 43 yeas and 48 nays, and the motion fails to pass. All right, now we're back to the original motion, the end consideration of amendments. Many of you in favor, vote yes. Those opposed, no. The clerk will open the machine. Vote your machine. Mr. Guyman, which way, Mr. Guyman, you going to vote? Mr. Cleckley, no. Vote your machine. Ms. Dorsey, no. Mr. John Smith, yes. Are you through voting? Are you through voting? Clerk will close machine. 42 yeas and 51 nays. Motion fails to pass. All right, Mr. Bruno, you... objection to the adoption of Mr. Bruno's amendment? That's B414. Any objection? Any objection? That objection stands adopted. Next amendment.
Is by Representative Ansardi. It is 360. Mr. Ansardi, 359 was adopted as an earlier version of Mr. Bruno. So your amendment is 360.
Representative Ansardi, on your amendment.
Mr. Speaker, members of the House, what I want to talk to you about today is really the whole premise behind my position and the position of, you know, a lot of folks in local government position of economic development agencies of New Orleans Inc. and others. And that is that we want to, at least I want to send a message, and I believe that we have to realize that economic development is not evil, it's not sinister, it's not bad. It's something that we all, when we campaign with the voters and when we talk to Rotary clubs and chamber clubs, we all agree to promote economic development here in the state of Louisiana. And we, over the past, have created dozens and dozens of economic development and industrial districts, and we have charged them with the responsibility of trying to promote jobs and opportunity by bringing projects into local communities. And in most cases, we've given them the authority to acquire property, to assemble property, what have you, to promote this economic development. We've given them the right to acquire it by lease, transfer, sale, and in most cases, expropriations. So what my Amendment 360 would do, and it would appear somewhere on page 2, around line 4 or 5, it would accept from the application of this bill any industrial or economic development district or authority created by general law. And the reason why I bring this amendment is to highlight to the members of the House that over the years, many of us who have been here for a long time have repeatedly voted to create economic development districts. We have the Ruston-Lincoln Industrial Development District in Mr. Gallo and Mr. Downs' area. We have the Sulphur Industrial Development District in Representative Johns and Cleckley's area. We have the St. Tammany Parish Development District in Representative Crow, Burns, and Schneider's district. We have the Catahoula Economic and Industrial Development District in Representative Kenny's district. We have the Avoyles Parish Economic Development District in Representative Walker's district, and perhaps in Senator McPherson's district. We have the Hammond Area Economic and Industrial Development District for the city of Hammond in Representative Carter's district and Tank Powell's district and Representative Winston's district. We have the Tangipahoa Parish Economic Development District. We have the Commissioner of St. Tammany Parish Environmental Services District. We have the City of Lake Charles Lakefront. We have the Chenault International Airport. We have the New Orleans Redevelopment Authority in the City of New Orleans. We have the St. Charles Parish Council, so on and so forth. And this has been a consistent public policy for the state of Louisiana, adopted by the legislature over decades, to create these type of districts to promote jobs, opportunity, and economic developments. And the purpose of the amendment is to allow these entities to exercise the full authority that we've granted them under the law. So I would urge adoption of the amendment.
Question on the amendment, Representative Robbie Carter.
Representative Anzardi, how does this amendment mesh with the one that Representative Bruno Cravens had? It says I can keep my homestead and 160 acres and don't have to worry about anybody taking it.
Well, what it would do is it would still allow these economic development agencies the opportunity to assemble other pieces of parcels, other pieces of land.
So if I don't want them to take my homestead, vote against this amendment.
Well, no, it wouldn't. It would just like we accepted ports and we accepted airports and we accepted industrial uses.
But if I don't want anybody to take my land, then I need to vote against this amendment.
And you need to vote against the bill.
No, I want to vote for the bill. What we needed to have done is to take some more of these entities out.
Well, no, if you don't want anyone to take your land, you need to vote against the amendment, and you need to vote
for
against
the bill, and then next year try to change it where we do even less. Take the ports and airports out next year.
Well, why take them out next year? Why don't we just...
I'd like to take them out now.
This year, it's before us right now, Mr. Carter.
I'd like to take them out now if we could get the votes to do it, but I don't think we could get the votes to do that. But I do think with Representative Bruno Cravens' amendment that we do have it where we're protected as good as possible, and I think this just opens a door to come back in and let somebody take out of my front pocket what was in the back pocket.
I don't agree. I think what it does, it reestablishes the policy, the longstanding policy of Louisiana legislature that we are going to do things to provide opportunities, to provide jobs, to provide a better way of life for our citizens. We've created these in your district and everyone's district, as I just indicated, and if we want to keep those districts viable and allow them to continue their mission to bring Louisiana up and not bring Louisiana down, we need to adopt this amendment.
All right, you're out of time. Representative Robbie Carter, do you wish the floor on the amendment? Okay, gentleman waves. Mr. Kazare, why do you rise?
Yes, Mr. Speaker, if you don't mind, I want Representative Carter to give us an illustration of taking something out of the front pocket that was in the back pocket. I don't get that one. I thought that maybe he might want to give us an explanation of that.
I might have to do that privately. So, Representative Strain, you wish the floor on this amendment? Come on down.
Speaker, fellow members, pay close attention to this amendment. It basically guts the bill, puts us back to square one. You know, there were some questions asked to me a while back about how many cases, how many times this was used in Louisiana. Well, there's different testimony we heard in Louisiana between 3 and 5 times. But what they did say is that this is a tool of the economic development people for you to be basically persuaded to sell your land. In our Constitution, it says that we shall protect your rights to property. It also says that these rights shall be maintained inviolate. If I, as a private individual, told you, you're either going to sell me this property for this much, or I'm going to take it and put it in the money in the bank, you know what happened to me? They put me in jail for that. But it's okay for the government to do it. Most of the time, it is. It's the big hammer of government. And if you think the average person on the street or the small or medium businessman can stand that fight, you're wrong. We need to go ahead and defeat this amendment, and let's pass this bill. Thank you.
Mr. Bruno, on the amendment.
Mr. Speaker, members of the House, I would ask that you join with me in welcoming the demise of this horrible amendment. I mean, what this does is say, regardless of what we do in the Constitution, people of the state of Louisiana, regardless of what you do in your basic law, regardless of rubbing you on the shoulder with this bill and saying, gee, doesn't it really feel good? We've preserved the right to private property, except whatever the legislature does here and after. That's no protection at all. So if you are in favor of the concept of limiting expropriation, you should vote against the bill. If you are in favor of having unbridled discretion with respect to local bills, and you know, we pass local bills just like that. We don't know what's in them. We don't know what they do. Somebody gets up and says it's local. And it's a general law that we pass. We are opening the door to undo what we have tried to do today, which is to limit expropriation. So I would respectfully urge each of you who are in favor of limiting expropriation to vote no on this amendment.
Representative Hilario for the floor on the amendment.
Mr. Speaker, ladies and gentlemen of the House, I too rise in opposition to the amendment. I think this is the whole basis of the argument that we're in. Either we're going to work to protect the property rights of individuals or we're not, and we ought not be trying to swap it out with any type of amendments that do this. We have talked about the basic protections in a constitution. The Constitution would provide a basic form of government for us, but it also has to provide a protection from that government for us, for the people that are there. And I believe this bill does it in its current structure without this amendment, and I ask you to please vote against the amendment also.
Representative Ansardi, you have a right to close on the amendment.
We're starting to hear from the proponents of the legislation what I call the Jim Mora argument, the woulda, coulda, shoulda. The woulda, coulda, shoulda. Remember those, you Saints fans, Jim Mora said in response to a reporter's question. And that's what they started to talk about. They're talking about, well, we don't have the problem, and I think I made it quite clear, we don't have the problem in Louisiana, but we coulda. That's why we need this bill. And Mr. Bruno asked you to vote against the amendment in order to limit expropriations. Well, I'm going to ask you to vote for the amendment to provide economic opportunities for our citizens in the state, to reaffirm the commitment you made and the pledges you made when you ran for office to promote economic development and to bring jobs and to bring hope and to bring opportunity. That's what we all ran on, every one of us. That's what we say constantly when we meet with business groups, chambers, and rotaries. So I'm asking you to vote for the amendment for the people of the state and to provide them a better way and to move our state up and don't bring our state down.
All right, Representative Ansardi is closed on the amendment. Representative Bruno requests a lockout. Would 20 members join him in that request? A lockout has been requested. 20 members join him. Are you through voting? Are you through voting? A lockout is obvious. We'll have a quorum call. Again, vote only your machine. Do not vote anyone else's machine. Vote only your machine. Mr. Ansardi is here. Mr. Tucker, Ms. Dorsey, Ms. Gray. Are you through voting? Are you through voting? Clerk will close machine. 93 yea of 93 members present at a quorum. Representative Ansardi has offered up an amendment which objection has been raised. Many of you in favor of the amendment vote yes. Those opposed, no. The clerk will open the machine. Mr. Ansardi, yes. Are you through voting? Ms. Dorsey, no. Are you through voting? Clerk will close the machine. 15 yeas and 75 nays, and the amendment fails to pass. Do we have other amendments, Mr. Clerk?
Representative Walker has 361. Ms. Walker, 361, she withdraws. And 361A is, you obviously withdraw that as well.
All right. For the floor on the bill, Representative Strain. Gentleman waves. For the floor on the bill, Representative Ansardi.
My colleagues are urging me to give up, but I'm not. I'm going to try to make some sense, try to maybe make you understand that economic development is a good thing. This is the wrong approach. This is the wrong way to go, especially considering the devastation of our coastline caused by the hurricanes. Now is not the time to put strict prohibitions to expropriation in the Constitution. And then everyone all admits, and I don't know how they explain the illogical provisions of the bill where they allow the taking for industrial use but don't allow it for commercial use. To me, it's just as illogical, and that's going to end up in the Constitution. If Mr. Bruno is wrong, or Senator McPherson is wrong, and as a result of this constitutional amendment, you have a very adverse decision of the Louisiana Supreme Court that prevents a very worthwhile economic development project from coming in, we are powerless as a legislature to try to address that. If you dealt with this in the statutes, it would be a much more reasonable and better approach, statutory limitations, providing, and there are other things that we can do to make this whole thing work a little bit better other than Senate Bill 1, and we've done some of them. One is to provide a better compensation formula to the homeowner or to the property owner when property is taken for economic development. I believe that's a better approach. Another approach would be requiring a two-thirds vote of the governing body of the political subdivision before taking property for economic development is a better approach. Requiring the right of first refusal, as Representative Farrar has in his bill, and they have in other bills, requiring the public body to offer the property back to the private property owner if it's no longer needed, is a better approach. Allowing our communities to decide how best to deal with blighted and abandoned property in special statutes and local ordinances, like we've done for the city of New Orleans when we passed the blighted and abandoned property statutes, we've done for Grambling, we've done it for Baton Rouge, is a better approach to deal with this issue. And as I said again, now is not the time to take away or to pass something like Senate Bill 1 that could lead to chilling and retarding economic development, especially since we need it desperately now to restore our state and restore our devastated areas. And remember, Pepe mentioned other states that have adopted it. Mississippi, who struggled with this issue in their recent legislative session, ended their session without adopting anything. And I'm going to suggest to you that if we find ourselves in competition with the state of Louisiana, rebuild our southeastern coastline while they're trying to develop and rebuild their Mississippi coastline, if we adopt something more restrictive, which Senate Bill 1 would be, then it may very well put us at a disadvantage. This issue, members, kind of reminds me of a real hot-button issue that was sweeping the country about 12 years ago, and that was the issue of term limits. And legislatures all across the country, as well as us, went ahead and we implemented term limits and stuck it in the Constitution. And for over the last several years, I haven't heard a big hue and cry about term limits. I think that if we give this some time, I think that if we address what's real and not try to address what's not real, the same thing very well may happen on this particular issue. I firmly believe that Senate Bill 1 is a knee-jerk reaction to a problem that doesn't exist in Louisiana. Let me say it again. It's a knee-jerk reaction to a problem that doesn't exist in Louisiana. And Mr. Bruno and others are going to say, yeah, but it could happen. Or, you know, it would have happened, or it could happen. But it didn't happen. The three cases that occurred in Louisiana, the cases we talked about, never involved the family home of anybody. It involved the taking of commercial real estate. In the Shreveport case, the commercial property was on the market. And when Shreveport started looking at it for a convention center complex, that sophisticated real estate developer took it off the market.
Begin to wrap it up.
To try to draw the price up. In New Orleans with the convention center, it wasn't owned by any family home. It was owned by a very sophisticated commercial developer who refused to sell the property and had to be taken to court. We don't have the problem here in Louisiana, and none of the supporters of Senate Bill 1 can identify a problem like they had in Kelo. And a much better way to address the whole issue is to do it statutorily and to do it very narrowly and not do it in this broad-based approach and not try to justify to the members of this House why it's good to take the family home for the industrial plant, why that's good, and why it ain't good to take it for the shopping mall. So I'm going to urge that you vote against Senate Bill 1 and let us continue to work on reasonable ways to balance the interest between property rights and economic development opportunities. And we've got bills coming through here this session to do that. So please, I'm going to urge you to vote against Senate Bill 1. It's not going to mean the end of the world. The sky's not going to fall. The Capitol's not going to slip into Capitol Lakes if the bill doesn't pass. There are other ways to address it. So I'm going to urge you to vote against the bill. Thank you.
The gentleman's out of time. Representative DeWitt for the floor. Gentleman who calls a question on the subject matter. There were 5 other people to wished to speak. 3 people had questions. Any objection to the previous question? Any objection? All right, there is objection to the previous question. Many of you in favor of the previous question will vote yes. Those opposed, no. The clerk will open the machines. Many of you in favor of the previous question vote yes. Mr. Hebert, no. Ms. Dorsey, no. Are you through voting? Are you through voting? Clerk will close the machine. 70 yeas and 24 nays, and the previous question has been called. Representative Bruno, you have a right to close.
Mr. Speaker, I yield just a minute or two of my time to Representative Schneider.
Representative Schneider.
Thank you, Mr. Speaker. Members of the House, I'll be much more brief than my friend that sits on my left, Mr. Bruno, from the great community of Lakeview and the Isle of Orleans. And you know, it brings to mind a quote that could be attributed to this man that was quoted by Mark Twain. And Mark Twain said, not very politically correct, Ms. Walker, no man's life, liberty, or property are safe while the legislature is in session. And we all have heard that before. Now, with your help, with the responsibleness of this body and the body across the rotunda, we've passed already gun right bills to save your life and your liberty. Now, by passing Senate Bill 1, we can save your property in the state of Louisiana. It's the responsible thing to do, and I thank you for your attention today.
You wish to yield to a question? Gentleman refuses to yield. Mr. Bruno, 3 minutes and 44 seconds.
You got it, Mr. Speaker. What are we going to do? We're going to wait until somebody seizes somebody's property to come back and say, oh, gee, that was such a shame. We're so sorry that happened to you. Boo-hoo-hoo. No, let's do a preventative strike. Yes, economic development is a good thing. To expropriate somebody's property for that purpose is not a good thing. It may be a very bad thing. This is not the wrong approach. This is the right approach. This protects your citizens' basic right to private property. And that is a basic right. Now, this state, because of what we've endured, because of what we've suffered, now is the time to prevent these vultures from profiting from the misery of our citizens. That's what we need to do. We need to stop it before it starts. We need to rebuild this state right. We don't need to rebuild it through taking people's property from them. We don't need to trample upon the right to private property. For after all, no matter how humble a person's home and property is, just remember, a person's home is his or her castle. Let government not trample thereon.
You'll yield to questions. Gentleman refuses to yield. Mr. Ansardi requests a lockout. With 20 members join him in that request. 20 members join him. Are you through voting? Are you through voting? All right, the lockout is obvious. Have a quorum call. Again, vote only your machine. Please do not vote anyone else's machine. Vote only your machine. Mr. Beard is here. Ms. Dorsey is here. Mr. Hebert is here. Are you through voting? Are you through voting? Clerk will close the machine. 94 members present and a quorum. Representative Bruno has offered up a legislation which objections been raised. Many of you in favor of the legislation vote yes. Those opposed, no. The clerk will open the machine.
Representative Beard votes yes.
Mr. Beard, yes. Ms. Dorsey, yes.
Mr. Hebert,
Mr.
yes.
Glover, yes. Mr. Hebert, yes. Are you through voting? Are you through voting? Clerk will close the machine. 89 yeas and 3 nays, and the bill is finally passed. Representative Bruno moves to reconsider vote which bill passed late at motion on table by objection so ordered.